Since our committee last met, we had a mass shooting at Bondi Beach in Australia. We had 15 people murdered because they were attending a Hanukkah celebration on a beach. It was a tragedy, and I think all members of the committee would join me in sending our thoughts and our prayers to all the people of Australia, and particularly to the Jewish community worldwide that was deeply impacted by this tragedy. And we saw what that shooting caused to happen in Australia, which is that a royal commission has been set up on anti-Semitism, and laws were passed by Parliament on gun control and on hate. And in fact, one of those laws proposed by the government of Australia and eventually adopted by Parliament was similar to things in the Combating Hate Act. And in Canada, we were being proactive. We were trying to pass these laws that police say will give them more tools before such a tragedy could occur, which theoretically could occur anywhere in the world. And there is great danger that tragedies like that could occur in any place in the Western world. We need to do our best to have criminal laws that give police the tools and intelligence services the tools to stop that from happening. Ironically, Mr. Chair, one of the provisions that was contested in the law in Australia was that Australia's Labor government proposed a hate exemption based on religious conviction that was similar to what we currently have in the criminal law in Canada. And ironically enough, the conservative parties in Australia, the Liberal Party and the National Party, argued that that exemption made the law useless. It's exactly the opposite argument that our colleagues are bringing here in Canada, that are saying that we need this exemption. In Australia, our conservative party said the opposite. So, look, I don't think taking out this exemption is a panacea, nor do I think having this exemption to allow somebody who has already promoted hate and charged with promoting hate, having a defense that has never been successful in Canadian history means a lot either. But the claims that have been made, Mr. Chair, and this is why I want to get to the amendment and the sub-amendment, but I want to start with the larger principle. The claims that have been made that people will no longer be able to preach the Bible or the Torah or the Quran or any religious text without being charged with hate speech is absurd and doesn't deserve the credence that is being given to it. I can't even believe these arguments are being made. This was a defense in the law if you have already been charged with the already high threshold of promoting hate against an identifiable group. And then you were able to claim that you did that hate, that horrible hate, based on sincere religious conviction. I don't know of any religion in the country that promotes in their mainstream religion that kind of hate. So taking this out should be not a problem. I don't think it makes a great difference, but it shouldn't be a problem. And I wanted, Mr. Speaker, to put on record the op-ed written by Joseph A. Newberger, who's a criminal lawyer and the chair of the Canadian Jewish Law Association, that was written in the Toronto Sun. So I'm going to read that for the record. Claims that C9, the Combating Hate Act, threatens religious freedom in Canada are false. They are not supported by the bill itself, by the Constitution, or by decades of court decisions. More than that, the claim that Bill C9 undermines religious freedom is not a matter of interpretation or reasonable disagreement. It is misinformation. Religious freedom is explicitly protected by Section 2A of the Canadian Charter of Rights and Freedoms and has been repeatedly affirmed by Canadian courts as a core constitutional guarantee. Nothing in Bill C9 amends, limits, or conditions that protection. The bill does not interfere with worship, belief, religious teaching, sermons, or doctrine. To suggest otherwise is to assert a legal effect that simply does not exist. What is C9? Bill C9 is proposed federal legislation that updates part of the criminal code dealing with hate-motivated conduct, hate propaganda, and the public promotion of terrorism. Its purpose is limited and clear: to address conduct that causes serious harm, including the glorification of terrorist groups and extreme hatred directed at identifiable communities. It does not regulate belief, worship, sermons, or religious teaching. It does not criminalize disagreement or political debate. Religious freedom in Canada is firmly protected by the Charter. That protection is well established and robust. Bill C-9 does not weaken it. What the Charter does not protect, because it never has, are threats, intimidation, or the deliberate promotion of violence or terrorism. Canadian constitutional law has always distinguished itself between protected belief and unprotected conduct, and Bill C-9 operates squarely within that settled framework. I write as a criminal lawyer with more than 32 years of experience, and as the chair of the Canadian Jewish Law Association. Since October 7, 2023, we have worked directly with students, professionals, and community members, Jewish and non-Jewish, who have faced harassment, exclusion, and intimidation. We have also contributed to anti-Semitism training for police and are preparing similar work with judges. The pattern is consistent. When hateful conduct is excused or ignored, it escalates. Canadian law already draws a clear line between strong opinions, which are protected, and extreme hatred, which is not. The Supreme Court of Canada made this clear in Regina versus Keekstra, defining hatred as extreme vilification and dehumanization, far removed from criticism or disagreement. Bill C-9 does not lower this threshold, it relies on it. Much of the opposition to the bill rests on a misunderstanding or misrepresentation of free expression and religious liberty. The Charter does not shield conduct that promotes terrorist organizations designated under Canadian law. No democratic society treats the public glorification of terrorism as a protected freedom, religious or otherwise. Another uncomfortable reality is that Canada already has laws to address hate speech, hate crimes and terrorism, but they are enforced inconsistently. On this, I agree with the author and agree with my conservative colleagues. That failure has contributed to a loss of civility and restraint, and to the normalization of conduct that targets people based on identity. Jewish Canadians have experienced this acutely, particularly when they are blamed for international events beyond their control, but the consequences affect all communities. Law alone will not eliminate hatred or extremism, but law sets boundaries. It signals what conduct a society will not tolerate. Bill C-9 reflects that responsibility. Bill C-9 provides authorities with additional tools to combat the display of symbols of terrorist entities and will provide additional protections for our most vulnerable religious and educational institutions, including synagogues, schools, and community centers. Bill C-9 is not the only answer to the rise in hate, but it is necessary to not only send a message that hate and anti-Semitism will not be tolerated, but will be prosecuted. I also write as a supporter of political campaigns, including the Conservatives in the last election. And I want to be clear that the real danger is not that religious freedom will be curtailed. The real danger is allowing false claims about religious freedom to obscure the actual purposes and effect of this law, and to prevent Parliament from responding to conduct that undermines safety, dignity, and social cohesion. Read plainly, Bill C-9 respects constitutional freedoms while reaffirming a basic principle. Freedom does not include the right to promote hatred or terror. So, Mr. Chair, I wanted to put that on the record because I believe in C-9 we have a bill that deals with many of the issues that have impacted our communities, particularly my own Jewish community, but other communities in Canada, and will be a positive force to tell law enforcement that we as a federal parliament are sending them a message that we expect the law to be enforced, whether when there are demonstrations in Mr. Baber's riding in Toronto that are entirely unacceptable, that target Jewish communities for absolutely no other reason than they are Jewish, or in other ridings across this country. And I think we all share that objective. So I will now come to the amendment that was proposed by Mr. Lawton and the sub-amendment by Mr. Brock, which I think, again, are misplaced. These are saying that the Charter guarantees in Section 2 remain. Well, obviously the Charter guarantees in Section 2 remain, but they remain for all parts of the bill, not just the subsection where this Charter right is now mentioned. The idea then, to me, would be a complete misinterpretation where somebody could look at this bill and say, oh, does that mean that Parliament intended those Charter rights not to apply to the rest of the bill? or to other laws where we don't expressly reference that Section 2 rights are protected, it doesn't make any sense because charter rights remain protected. We have not used Section 33 in this bill or anywhere else to remove those rights. And to insert them, I believe, for the first time in a bill to say that these rights are not undermined or thwarted would then cause doubt in every other bill and every other provision of the bill if we don't repeat the same message. So I would end my remarks, Mr. Chair, because I strongly support this bill. This bill is really important to me, as are the bills on bail and the bills on, giving greater rights to victims and dealing with intimate partner violence. But this bill is really important to me because this bill deals with something that I have requested Parliament do for almost 2 years now in terms of protecting schools and community centers and places of worship and other places occupied by vulnerable communities, and by taking actions against people that carry terrorist symbols in demonstrations. And I don't want to just let this bill go and delay it and cause it to disappear off the parliamentary radar because people are misinterpreting or misleading people about what religious rights are or are not included in this bill. So, Mr. Chair, I'm going to fight for this bill. I'm going to fight hard for this bill. And I'm asking my colleagues, if they disagree, that's fine. Let them vote against the parts of the bill they disagree with. Let them vote against the bill if they want, but let this bill go through clause by clause and come back to the House. Thank you, Mr. Chair.
Thank you, Mr. Housefather. Okay, next we have Mr. Bauer.
And welcome, everyone, and Happy New Year to all of you. Before I defer to my colleague, MP Larry Brock,